Respectfully, I'm challenging the jurisdiction.
Ballard, you may pursue whatever appellate rights you wish to pursue.
You cannot make a
Obviously, you
ruling over
disagree with
something
my
that
order.
you don't know.
I'm sorry, Ms. Ballard.
I mean, ma'am, I object. I object.
Before we even get into this hearing, let me set the stage, because what you're about to witness is a courtroom showdown over jurisdiction, legal tender, and a payment that may or may not exist. The defendant is challenging the court's authority. The judge is demanding proof of payment, and at the center of it all, a so-called bill of exchange that the court says doesn't count as legal tender. Now, here's where it gets serious. In eviction appeal cases like this, if you don't deposit the required payments into the court registry, the appeal can be dismissed automatically, no debate, no second chances. So the real question becomes, was a valid payment actually made? Or is this a misunderstanding of what legally qualifies as money? Pay close attention, because this case turns on one critical issue: what counts as legal tender in the United States, and who carries the burden to prove it? Let's get into it.
I'm not going to call your case formally right now. Right now, what I'm looking for is how long do you think that it will take to present what you want to present to the court today?
To my understanding, has the court reviewed the affidavits that has been submitted?
Yes, ma'am, I have.
Okay. So what can I expect as far as procedure? How will this hearing go?
Well, so typically what will happen, sometimes people choose to do that. Some people don't choose to do that. But the idea is that if you wanted to explain to me what your position is in some shorter or different way from how you put it in the filings that you made, and then I would call on Ms. Akpati on behalf of her client to make a response. And then typically, because you're the movement, I would let you have the last word. And then sometimes I rule during the hearing. Sometimes I take it under advisement. It just depends on the circumstances. But if you wanted to make a presentation to outline verbally for me what you believe are the important issues, how long would that take?
I'm not sure. To my understanding, with this hearing, I was under the understanding that the affidavits that have been presented are fully understood, and that based on what I have submitted, that there would be a proper decision and ruling.
Okay, so I'm interpreting that, Ms. Ballard, as you wanting to rest on the materials that you've sent, and that's perfectly fine. Ms. Akpati, what presentation, if any, did you intend to make? I'm just trying to get a time idea of how long this might take.
5 minutes, Your Honor.
Okay.
From my position, I filed an affidavit of priority interest in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity, I'm requesting that this motion under the titles, under the Rule 60B, that, this is thrown out. It just, we don't have a contract. There's nothing to really argue here. So, it's clearly displayed and stated in the affidavits that I submitted. And bottom line, we don't have a contract. The other entity does not own this property. I have priority interest and equity in this property.
Part of the order that was entered against you, which you are challenging here, right? That the magistrate judges, the purpose of this action is because the magistrate judge entered an order that said that you were not entitled to possession, and that and you're challenging that order. And I understand that part. But part of the order also requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put an affidavit to ask for rent. So, and there's no contract, but I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it. It's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order from Magistrate Judge Brooks.
Ms. Akpati?
Your Honor, just to get straight to the point, no payment has been made. I did call the court this morning, and there has been no payment made. So if Ms. Ballard is saying that she has made the payment, could she provide to the court some form of evidence showing that she's made the payment? Because again, as of 15 minutes ago, no payment has been made.
I'm happy to follow up with the court because sometimes the clerk gets a little bit behind, but do you have any documentation regarding when you made those payments or the amount of the payment?
It was a couple weeks ago when I filed it into the court of registry.
Okay, what did you file? Did you file like a proof of payment, or what did you file?
It is basically a money order.
Actually, that's not correct. So the file indicates, Ms. Ballard, the file indicates that you submitted an affidavit of poverty, and that poverty affidavit was granted for the filing fee. So you didn't have to pay a filing fee to be able to open this case.
Respectfully, I tendered a payment in the magistrate court.
Right. I'm not questioning, Ms. Ballard, that you did. What I'm saying is I need some documentation of that payment because there's no such payment reflected in the magistrate court.
According to law, I tendered the payment, and I don't know if there's some type of mix up between both courts, but I filed it in both courts. The tender payment is there respectfully. Otherwise, I would not have been able. They even said this has to be satisfied in order to get a new case number for this appeal.
Ms. Ballard, I understand that. All I'm asking is, can you tell me what was the amount? When was the payment? Where did you get the money order from? That's the type of information that I would then be able to go to the clerk and confirm that information.
Okay. So
yes, ma'am.
I filed a notice of tender payment into the courts and tender payment to the courts, and I'm sure you can see the affidavit in there, and it has proper endorsement. It's been properly endorsed.
Give me a moment to look in the file and see what I can locate. Okay. Give me just a second. My review of the notice that you filed. So first of all, I've spoken with the clerk of court, and they have no record of any payment. They have looked everywhere they can think of, including associated with your name, associated with this case, associated with the Superior Court case, and they can find no record of payment. But more importantly, Ms. Ballard, my review of your filing seems to indicate that you are rejecting the acknowledgement that there is that money would be any like it doesn't appear that you actually submitted legal tender of any sort to pay or satisfy this. You instead submitted some sort of signed, some sort of authorized representative document, but no money order, no check, which I don't think they take, no cash, no certified check, anything like that. Is that an accurate statement? Am I correctly understanding what you filed, Ms. Ballard?
I filed a tender payment, and it didn't. I mean, the law says that I can tender a payment. It never stated how to pay it. So, I mean, I did. I fulfilled the contract based on the order. I mean,
I'm sorry, are you saying it wasn't specific in amount or it wasn't specific in method?
in method, yes.
Okay. I disagree. This is a standard order, and the vast majority of everyone I've ever dealt with that deals with these orders understands that when it says tenant must, in capital letters, make the following payments into the court registry by the time specified, everyone understands. And in the absence of those things being paid, then the court wouldn't have any choice but to dismiss the appeal. And so
I gave you a bill of exchange, which is the same thing.
I'm sorry, ma'am?
I gave you a bill of exchange, which is the same thing.
No, ma'am, it's not. A bill of exchange is not recognized as legal tender in the United States, and therefore it would not satisfy the requirement that tenant must make the following payment into the court registry.
Will you be so kind to confirm under what law?
For that reason, I am dismissing case number.
I mean, ma'am, I object. I object. I mean, it's there. Under what law does it say that it is not a legal payment, a legal tender?
So, in all honesty, I don't know the answer. I could do some research and find the answer, but Ms. Ballard, it's your obligation as the movant to provide the information that the court requires in order to understand your case, to accept your case. And you have not provided me, more importantly, with any documentation or a legal citation that would provide me with some sort of basis to accept your providing me with this note of exchange as legal tender. As I said, my understanding of the law is that a note of exchange is not legal tender recognized in the United States, and therefore it does not constitute a payment.
You have not provided me an answer, but under what law?
Yes, ma'am, I did. The answer I gave you was that it was your obligation. Mr. Freehold, please mute Ms.
I need
Ballard
to finish what I have to say.
Mr. Freehold, please mute Ms. Ballard if she's going to continue to speak over me. Thank you. Ms. Ballard, you've been muted because you continue to speak over me, which is disrespectful to the court.
I'm not trying to be respectful. You're
Ms. Ballard,
and not properly.
You are continuing to speak, and Ms. Ballard, stop. I understand that you do not like the outcome. I understand that you believe that that legal tender or notice of exchange that you gave me should count, but it does not. The answer to this question is that the order that was entered says that tenant must make the following payments into the court registry, and there were no payments made into the court registry, and the filing that you submitted does not constitute a payment of legal tender into the court registry and does not constitute compliance with the order that you make a payment into the court registry. And therefore, the case is going to be dismissed.
Let's break down what just happened. This entire case hinged on one procedural requirement. When appealing an eviction or possession ruling, the appealing party must deposit required payments into the court registry. That's not optional. It's mandatory. The judge repeatedly clarified that no official record of payment existed in either court system, and without documented legal tender, meaning recognized U.S. currency, certified funds, or approved payment methods, the court had no legal basis to keep the appeal active. Now, here's the key legal principle. The burden of proof falls on the person filing the appeal. If you claim you paid, you must provide documentation, receipts, confirmations, payment records. A bill of exchange or similar instrument is not recognized as legal tender under U.S. law unless specifically authorized. And because no valid payment was confirmed, the judge dismissed the case for lack of compliance. Emotionally, you could feel the frustration building. Legally, the ruling followed procedural standards. Now, I want to hear from you. Do you think the judge handled this correctly, or should there have been more investigation before dismissal? If you found this case as intense and revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Case number 2023 CV 390111 will be dismissed for lack of payment. Anything else that the parties need? Ms. Ballard, you may pursue whatever appellate rights you wish to pursue.
You cannot make a ruling over something that you don't know.
I'm sorry, Ms. Ballard.
You
I
cannot make
did
a
not hear
ruling
you.
over something you can't know. You saying you don't know is an unacceptable response, respectfully.
Ms. Ballard, as I said, my answer was, if you would like to direct me to case law,